Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
And I'm Darien Murray.
Welcome to Hull on Estates. You're listening to episode number 679. Darien, how are you today?
I'm pretty good. It's nice and sunny out, which has been a nice change. So it's a good day. How are you?
Oh, yeah. I'm good. I'll take this sunshine whenever we can get it at whatever hour we can get it, because apparently it all disappears by 4:30.
Yeah.
I'm not okay with that, but guess there's nothing I can do. So today, you actually brought a really useful case, I think. It goes through, I think, for like estate litigators, estate administrators, and estate planners, some like really core concepts that perhaps are taken for granted a lot of the time. Like it really just goes back to these first principles in terms of property ownership and gifts, and maybe what you can or cannot do with a gift once it's already been given. It's a really neat and easy read. It's called Jackson and Rosenberg. It's from the Ontario Superior Court of Justice, Justice Charney, this July. I believe we've blogged on this case before as well. And you'll find the citation on our website. At the end of the day, this is about what has gone horribly, horribly wrong as a result of somebody who fully owned a property. Mr. Jackson fully owned this particular property in Port Hope. He was a 100% legal and beneficial owner. And then when he was thinking about what he could do on the estate planning side for himself when he died, he already had a will in place, but he thought like, oh, well, you know what? I heard this thing where if you put your property into joint tenancy into like the intended beneficiary, then that beneficiary will save on probate fees. Oh, great. Sounds good. I want to save money. Nobody likes taxes. Let's do it. Well, again, this is where it goes horribly wrong. So, Darien, tell us all about the facts of this case and how, unfortunately, it all kind of went horribly wrong for Mr. Jackson.
Yes. So, like Doreen was saying, it was intended as a great money-saving method. He was trying to help out the beneficiary, but that is not what ended up happening. So, Mr. Jackson and his partner, Mr. Tobe, had been together since 1963. Mr. Tobe predeceased all of this litigation, but the respondent in this was Miss Rosenberg, who is Mr. Tobe's great niece. So Mr. Jackson and Mr. Tobe had originally drafted their wills together, and they had used this probate tax saving technique as well. So they owned a condo in Yorkville that they put in both of their names as joint tenants. The intended effect was that whichever one of them passed away first, that property would then immediately go to the survivor of the two of them by the right of survivorship. So they did this because, like we were saying, then the property would pass outside of the estate and they wouldn't have to pay probate fees on that. So Mr. Tobe passed away first in 2010, and his will actually was never probated because the main/only asset in his estate his biggest asset was the property, which then passed outside of the estate, so there was no requirement to probate the will, and therefore they didn't have to pay probate tax. So Mr. Jackson inherited the property. He then, in 2011, sold the Yorkville condo and bought a property in Port Hope. And when Mr. Jackson and Mr. Tobe had originally drafted their wills, they had both left everything to each other, and then both of them made Miss Rosenberg as the alternate beneficiary. So whoever passed away second would end up gifting everything to Miss Rosenberg. So likely because this whole joint tenant right of survivorship thing had gone so well the first time around, Mr. Jackson then went to his solicitor and said, hey, Miss Rosenberg is going to be inheriting this property when I pass away. I want to make her a joint tenant so that, again, when I pass, the property will pass to her outside of my estate and she won't have to pay probate fees. And then this is where things went wrong. Mr. Jackson ended up putting the property into both his name and Miss Rosenberg's name as joint tenants. And then I guess Miss Rosenberg's husband went to Mr. Jackson and had a conversation saying, yeah, we're going to improve this Port Hope property so that we can sell it. We'll buy this nice property on a golf course and you can move in there with us. So Mr. Jackson then got scared because he didn't want them to sell his home out from underneath them. Miss Rosenberg had never lived in the property with him. There was no intention she was ever going to live in the property. She never contributed to it financially, nothing. This was just done as a probate fee saving method. So Mr. Jackson then went back to his lawyer and asked him to sever joint tenancy because he didn't want the property to be sold out from underneath him in any way. And then he brought this application asking for a declaration that Miss Rosenberg only held title to the Port Hope property in a resulting trust for him, and that he was 100% beneficial interest, and she didn't have an interest in the property at this time. And then, as a result, Miss Rosenberg brought her own application seeking a declaration that she was a beneficial owner of the Port Hope property. So the big question came to be, did Mr. Jackson transfer title to Miss Rosenberg as an outright gift, or was she holding it as a beneficial, was she holding it in trust for Mr. Jackson?
Yeah, and all of this is really important because, when you think about just you're planning for your death, and this is where you want your assets to go when you're gone. And of course, anybody who cares about the beneficiaries that they've named would want them maybe to receive the largest possible gift that you can give them, right? Maybe it's actually in a different scenario, your wife and kids, and you just want them to have as much money possible as what's going to be left when you die. And so this is why people want to plan around probate fees as well as income tax, if you can. But all of this planning is great if it only takes effect, gives those rights, have those savings be the consequence when you die. Whereas this joint tenancy strategy in relation to estate planning, it takes place right away. So when you're using a joint tenant registration so that the other joint tenant will receive the entire property when you die, that gets registered from the time that you actually do it, and it gets registered during your lifetime. It doesn't get registered after you're dead, and that's not how probate fees are avoided, because then at that point, probate fees can't be avoided, right? You can only avoid probate fees because you're avoiding that transaction when you die. You have to do it during your lifetime. But once you actually do something during your lifetime and, you're changing title, for, Miss Rosenberg's perspective, or anybody that just pulls title to the house, they're going to think okay, she's a joint owner. If Mr. Jackson wants to sell the property, Mr. Jackson wants to mortgage the property, they're what does Miss Rosenberg want? She's also entitled. We need her to sign off. And so this is where it gives Miss Rosenberg, this joint tenant, at least on paper, a lot more control than I think Mr. Jackson would have ever wanted for himself, especially when he got spooked by that conversation with her husband. And so yes, he actually did what any joint owner is entitled to do, which is sever that joint tenancy so that at least he knows okay, there's one half of it that she'll never be able to take from me, and I'll still be able to deal with on my will in a different way if I still want to. But then what about this other half? And this other half, then he's really exposed. Now they're tenants in common, and maybe she can bring an application for petition and sale and then still throw him out of the home that way. And really it's too bad, because this is, I think, every testator's worst case scenario while they are alive. Now, these worst case scenarios for testators while they're gone, like, yes, that's really regrettable. It's not what they would have ever wanted. But I really don't think any testator making a will to get their affairs in order while they're alive would want to have these problems visit them while they're still living. Like, poor man is now elderly and is afraid that he's going to be kicked out of his home, right? And like at the time when the joint tenancy was done, did he like really truly understand the extent to which like his relationship with Ms. Rosenberg is gonna have to be like Rosie? He's gonna be able to stay control until like the moment that he dies. She's always gonna sign off whenever he asks her to. And is she ever gonna cause any trouble for him? Like, she's not his niece, right? I don't even know the extent to which like, you know, Mr. Rosenberg actually knows him. It just, the decision says like Mr. Jackson didn't have any family of his own. He didn't really have any intended beneficiaries. He was just, you know, happy to like have the alternate that was selected like by his partner. There are also where these like joint tenancies go, there are a lot of these like core property concepts that like exist as law, that are these like first principles that, again, sometimes like we all take for granted because we don't like think about like every stepping stone that we have as we like go about doing any one thing. But you know, when like the pyramid falls, that's when you have to like really look at it, right? So on title or real property, those are like the like registered legal owners that like you see on a personal abstract. And here in this one, by the time Mr. Jackson did the joint tenancy, you see his name and you see Laurie's name, and they're on a joint tenant. What could have also been done at the time of that, like, of the joint tenancy is actually an agreement amongst the joint tenants that the transfer into joint ownership is subject to this agreement that really clearly documents the intention for this resulting trust, that Ms. Rosenberg is only a joint tenant as a trustee for Mr. Jackson while he's still alive, but that she gets it outright with the right of survivorship to take place like upon his death. That could have been documented in an agreement, and that agreement itself just also distinguished Ms. Rosenberg's right to sever the joint tenancy, to bring any applications for partition and sale. So like if documented properly, like at the very beginning, perhaps all these like, you know, issues could have been avoided, or at least like the court will need very little evidence except for this like one contract to make a fulsome decision, and they wouldn't have to go through like either like a full application with cross-examinations and affidavits, like et cetera, et cetera. But, you know, when it comes to like was there resulting trust or not, was the joint tenancy, like even at that point, a gift of like the full right of a joint tenant at the time it was done, this is where like the court really has to like decide like with the evidence. And then you actually then also look at the first principles of like the law on gifting. Darien, to you know like the 3 requirements on what it takes to establish a gift to prove that a gift was given to you.
Yes. So these 3 conditions come from the case McNamee and McNamee, which is a Court of Appeal decision from 2011. So in order to establish there was a gift, the person receiving the gifts needs to satisfy 3 conditions, which is an intention to make a gift on the part of the donor without consideration or expectation of remuneration. The second is an acceptance of the gift by the donee or the recipient of the gift. And the third is a sufficient act of delivery or transfer of the property to complete the transaction. And this was a big kind of hill she needed to get past in this situation, because Mr. Jackson did gift Miss Rosenberg, gave Miss Rosenberg this interest in the property for no consideration. So in this situation, when that happens, when you give a gift without consideration, without Miss Rosenberg paying anything back, there is the presumption that you're giving it to them in trust, because kind of the standard of our society is like, we don't give anything away for free, really. So that's why that's that big condition of proving a gift is that this person actually did intend to give you this piece of property or whatever it was for nothing.
Right. So, like, if Ms. Rosenberg was actually successful, then that would have blocked Mr. Jackson's ability to, like, say, sever the joint tenancy when he did during his lifetime. Because if there was an enforceable gift that was given to Ms. Rosenberg, the law does not allow you to take things back. Right? But this is where, like, the onus is on Ms. Rosenberg, where inter vivos gifts are concerned, to establish that she did receive an enforceable gift. So it really starts with, what did the person who gave you something truly intended at that time? And then only when the court had made all of those findings about what was actually intended by the person who gave something away, then you look at, well, did this recipient of a gift, did you actually accept it? Did you want this? Did you want it? And did you want it on the condition that it was, like, given to you for? And then, like, obviously, assuming yes, you say yes to free things, then the third thing is there's sufficient delivery. Delivery is also really, really important, because sometimes you actually get into, like, those cases as well, where someone intends to give you something and you say, yes, please. And then it comes time to actually, like, do the transfer, do the delivery, then the person finds out, like, oh, actually, I can't give you this because I don't have it to give in the first place. There could be some issue where, like, it turns out, despite the fact that I had every intention of giving my beautiful mug to Darien, and Darien wants my beautiful mug, it turns out when I try to give it to Darien, oh shoot, it's the property of Ian Hull, and I can't give Darien Ian's mug after all. And so, like, that's where there is this, like, 3/4 of, like, how then it becomes enforceable. And that's why the court really has to look at, well, what is done that can't be undone before it reaches its final conclusion. Now, I am going to skip ahead and just tell everybody what the court concluded. And I think because of the way, we've been talking about the case, I think it's very clear that Mr. Jackson did prevail at the end of the day. It's not that sad of a story. But in a way, he was able to take back some part of the gift that he did give to Ms. Rosenberg way back in 2012, but not the whole thing. And so Ms. Rosenberg actually is still, on Mr. Jackson's death, going to receive as an outright gift 50% of this property. And, like, the way you get to the analysis as to how the court actually came to this conclusion, because you might think, like, oh, what? Mr. Jackson didn't want her to have any percent of this property anymore. Like, once the litigation started, or once he got, like, spooked by her husband, he didn't want her to have any of it. But she still get 50% on his death. Why? Well, why is, like, where the decision does a really, really nice job of setting out these, like, core property law concepts of what you could do with joint tenancies, your right to sever, all the issues that come with joint tenancy, all, like, the first principles on, like, the gifting, the law on gifting, like we were saying with McNamee, the core with how we have these, like, resulting trust concepts in the first place. So what the court found is exactly what Mr. Jackson had intended in that first place, which is, it's really just to save probate fees. Ms. Rosenberg is not supposed to get anything more than what's left of this property when he dies, and it could be subject to a mortgage, and so her gift when he dies would be subject to a mortgage. It'll just avoid those probate fees. Now, as a joint tenant, while you're still alive, any joint tenant can sever the joint tenancy. And in this case, with our jurisprudence in Ontario that has yet to really precisely answer this question by our Ontario Court of Appeal, Justice Charney decided, yes, you can still sever this joint tenancy while you're alive, despite the gift of this like right of survivorship back in 2012 for estate planning purposes. And it's really interesting because the decision does a good job of actually like referring to other jurisdictions, other provinces in Canada that says like, no, you can't do that. It's too late. You can't even like sever that 50% anymore. But in Ontario, based on this Superior Court decision, you can. And so that's where we're left with a scenario where Mr. Jackson can't take back 100% of the right of survivorship where this property is involved, because you can, at least in the Superior Court decision in Ontario, still just sever the joint tenancy, which sever means cut it back in half, or cut it back equally in equal proportions to however many joint tenants there are. And then so half of it is still going to go directly to Ms. Rosenberg when she died. The other half will go to his estate, and he is free to change his will whenever he wants. And then during his lifetime, he is still free to do whatever he wants with 100% of his property. So, this is where I say there was still a little bit of a take back, and maybe a little bit of a take back that you might not be able to get in a different province in Canada. And you make the decision, you'll be able to find out which one. And of course, again, we don't actually have Ontario Court of Appeal comment on it. But again, it's a decision that I think like really should be like read in full, and if like not like say like taught in law school and other CPDs, because it's a really nice way. It's a really nice back pattern that lays it all out. And I guess back to the first principle, the reason why anybody can change their will up until like the moment that they die or they lose the capacity to make changes to the will. And it's very different than like how, once you satisfy the 3/4 of that enduring gift that we were talking about on Magnum, you can't take it back at that point. Like, it's because wills don't come into effect according to the Social Law Reform Act until you die. So like that whole document, despite the fact that it's fully signed, it doesn't come effect under the statute until you die. And so then you can see, there's no delivery until you die, because the document doesn't come into effect by virtue of statute until you die. And also, a lot of times there's probably like no acceptance at the time the will was signed, because you also don't have to tell any beneficiary that you signed a will. You don't have to like send it to them beforehand before you sign. This is why like wills are unilateral documents that are fine, and that does take it out of this like interviewable gift realm where like the recipient does actually have to accept your gift. But again, that's not to say once the will does come into effect on death, that beneficiary can always decline the gift at that point, but it's not a legal requirement for them to have accepted it before you die or the will to be enforceable and come into effect on death. And so that's where you get like those like nuances and differences, but it's like everybody just like takes it for granted, like what happens when you die. But the planning that you do before you die, sometimes it could take place right away. And again, so this is where we got into like the danger zone. But luckily we have a really well reasoned and really well written decision from Justice Charney, and I think Mr. Jackson it's still going to have his peace of mind. He's still in charge of where he lives. So until next time, this is our podcast for today. Should you have any questions, please email us at info@colandhull.com or contact us through the contact page on our website. That includes our podcast. Until next time, I thank you for listening. I'm Doreen Poe.
And I'm Darien Murray.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.